Okay, Chevra, our learning should be for the Zuchus of Achenu B'nai Yisrael. This is not a topic that's in any way related to wartime, but it's something that we raised a lot of discussion in our. We have a regular Choshen Mishpat Shiur Monday through Friday at 6:10 a.m. before the 6:45 minyan, and we recently started a new sefer called Baruch Omer, which is from a dayan named Rav Baruch Sharaga, who is either retired now, who's quite a bit older of a dayan, but he was on the dayan of the Beit Din HaGadol of Yerushalayim, and brings case after case of different really halacha l'maisa issues in Choshen Mishpat halacha. So I think I'm just going to. Okay. The general principle that we really want to discuss tonight is, as many of you probably know, when you have a dispute with a fellow Yid, you're supposed to take them to Beis Din. And yet we do hear from time to time, we do hear of situations where one Jew will take another Jew to secular court. Now, sometimes there's absolutely no heter for it. But there could be situations where there is a heter that one of the parties may have received a heter to litigate in secular court. I don't know that it's necessarily appropriate to make that assumption, but you know, it's important to encourage people to go to Beis Din. Now, so the first thing I want to point out is that this halacha, that it's important to go to Beis Din, is a very, very serious halacha. It's based on a Gemara in Gittin Daf Peches that says, Tanya Haya Rabbi Tarfon Omer, Kol Makom. Now, let me just actually share the screen here with the people who are watching. Okay, so you have the sheets in front of you. The Gemara says, Kol Makom Sha'atamotze Agurios Shel Ovdei Kochavim. Anytime you find judicial gatherings of heathens, Afal Pisha Dinehem Kedine Yisrael, even when they are judging according to the same ruling as you would get in a Beis Din, I ata rashai lihizakek lahem. You are still not allowed to appear before them. Shenamar, as it says, ve'ela hamishpatim asher tasim lifnehem. As it says, these are the laws that you shall place in front of them. Them meaning the Jewish judges. Lifnehem, below lifnei ovdei kochavim. In front of them and not in front of idolaters. Now, one of the shilas that we dealt with is, how does this have applications when you're, let's say, going to a secular court in Eretz Yisrael today? You're going to a court in Medinat Yisrael instead of going to a Beis Din. It seems that the consensus of the poskim is that here the term Ovdei Kochavim does not strictly apply to an idolater, but it applies to anyone who is assembling a system of justice that does not that has not been put together under the rubric of Beis Din. And that's really what this Gemara is saying. It's a machlokes among the poskim as to whether this is a mitzvah deoraisa or a mitzvah derabbanan. It seems from the face value of the Gemara that this would be a mitzvah deoraisa because it's based on a pasuk of Asher Tasim Lifnehem. However, there are those who wish to suggest that it's only an asmachta ba'alma and that this is a mitzvah derabbanan and that this is not really the true derivation from the pasuk. But the majority of poskim do learn that it is a biblical obligation to go to Beis Din when you litigate against another Jew. We'll learn two seifim in Shulchan Aruch in Siman Chav Vav. The first sif says, The Mechaber writes, Asr ladun bifnei dayane ovdei kochavim uve'erkaot shelahem. It is asr to adjudicate in front of judges who are idolaters and in their court system. Perish moshav kavua lisarehem ladunbo. Any kind of fixed court that they establish. Afilu bidin shedanim bidina Yisrael, va'afilu nitratzu bet ba'alei dinim ladun bifnehem asur. And this is true even if the outcome of the case would be no different had the two litigants gone to Beis Din. You're able to establish that the legal rulings are the same in a certain kind of area of law. And even if both litigants prefer to go to secular court, both of them are consenting to go to secular court, it is still usr. Why? Because you're creating a chilul Hashem. You're basically demonstrating that you would rather adjudicate the rules of your life according to a foreign set of principles or a foreign set of judges over the rules of the Torah. V'chol haba lidon bifnehem, anyone who does appear before a court, hareze rasha, this is a wicked person. V'cheilu chereif v'gideif v'herim yad b'toras Moshe Rabbeinu olav shalom, and it is as if he has blasphemed and lifted a hand against the Torah of Moshe Rabbeinu. You're basically saying, I hold that the Torah of Moshe is less important than the rulings of a particular court. I feel I'll be able to get a better judgment in the secular court. Now the Ramah says, V'yesh biyad Beis Din lanadoso ulahacharimo ad sheyasalek yad ha'ovdei chochavim me'al chavero. If Ruvain sends a summons to Shimon that he should appear before a secular court, Shimon has a right to complain to the Rabbanim of the community, and the Rabbanim of the community, the Beis Din of the community, can place Ruvain in cherem for litigating against a fellow Jew in secular court. And it is appropriate for them to do so. Them's were the good old days, right? Now, have you ever heard of anyone doing that today? No. We know that unfortunately, this does not exist at all. Don't ask me why. There are certain things we don't know the answer to. And they would also put anyone who supports that person, who goes before the secular court, anyone who supports him and gives him, let's say he's got a lawyer, right? Anyone who aids and abets him, they would put that person in cherem as well. The Mordechai goes so far as to say that even if you don't take a person to secular court, but you get the authorities involved to coerce someone to go to Beis Din, that too is wrong. And they would put that person on the amud, on the post, to give him lashes. Misha, and then finally, the Ramah says a very important halacha that can also happen in the real world. Misha halach be'erkos shel ovdei kolchavim v'nischayev b'dinehem. If a person took his friend to secular court and lost the case, v'achar kach chazar v'tovo lifnei dayane Yisrael, and says, I've become a Baal Tshuva, and I've decided that I'm a From Yid, you're a From Yid, we should go to Beis Din. The guy says, what are you talking about? You just lost in secular court. I know, but we have to do the right thing. So I'm going to take you to Beis Din. So yesh omrim she'ein nizkakim lo, yesh omrim din nizkakim lo. So one opinion, says the Mechaber, that we don't listen to such a person. What, you're sending a hazmana after you lost in court? It's clear that you're playing games. But some others say that you are nizkakim lo, that now that the person really wants to do the right thing, or that at least he's going through the motions of doing the right thing, then you do entertain his summons. Unless he has already caused a monetary loss to the other litigant. In other words, if he's caused him to lose money by having to hire a lawyer and having to pay court fees in order to defend himself. Once you've done that, then everyone agrees that the Beis Din does not have to listen to this fellow's demand to be heard in a Beis Din. V'hasvara rishona nira li'ikr, and the Ramah says, and besides, I hold like the first argument, the first side, which is that once a person has started a court case in secular court, you don't listen to him. The poskim, by the way, say that this is not just if he lost the case, but even if he would just began the procedure in secular court, you no longer have to listen to him and take the case. The Beis Din no longer has an obligation to listen to him to take the case. And I actually had experience with this many years ago when I was a trustee on an estate, and the decedent had no heirs, and the trustees were in charge of distributing the bulk of his estate to various charities. One local charity stepped forward with some very suspicious promissory notes that the decedent had allegedly signed before he passed away that would have been worth about 60% of the decedent's estate. And they demanded that we honor those promissory notes. And the trustees, under the advice of our posek, said, no, take us to Beis Din. We'll happily go to Beis Din and we'll adjudicate this in Beis Din. They decided, no, we're going to take you to secular court. They started secular proceedings against us. We lawyered up using the testator's money from his estate. They lawyered up. They saw that their case was not doing well. They said, we should really go to Beis Din. And so we asked our posek, and our posek said, Al pi Shulchan Aruch, you don't have to go. But you know what? This money is going to Moistas HaTorah. Go to Beis Din and you'll be fine. So we said, okay. They withdrew their case and they took us to Beis Din, and we willingly went. They lost the case, and they had to pay for all the court fees in addition to that, which is an unusual ruling for the Beis Din to make. The Beis Din imposed certain penalties because this charity proved to be dishonorable. Anyway, going forward, let's just learn one more sif in Shulchan Aruch. Hayisa yad ovdei kochavim takifa uvaldin ilaim ve'eno yachol lahatzil mamono b'dayane Yisrael. Or I'm not sure how to pronounce that word. Is it ilaim? I'm not sure if that's the correct pronunciation. But when you have a situation where the secular government is in power and your counterclaimant is a person who is aggressive or tough, and you're not able to move him to go to Beis Din, and you're not able to sue him in Beis Din because he refuses, yitzva'enu l'dayana Yisrael techila. So you should send him a summons to appear before the Beis Din. Im lo ratza lavo, if he refuses to go, no tel rishus mi Beis Din umatzil b'dayani ovid kochavim miyad baldina. Then you will get permission from the Beis Din because this fellow has refused to go to Beis Din. And then and only then will you have the right to sue him in secular court. So there are many cases where you have a situation where a person will, let's say you want to sue somebody, and he's perhaps not as religious as you would like, and you send him a hazmana to Beis Din, and he says, I'm not going to Beis Din, take a hike, and he blows off the hazmana. In that kind of situation, if there's different protocols that the poskim discuss as far as how many hazmanas have to be sent to the person before they will basically write the person off. They will then give formal permission in writing to the claimant, to the plaintiff. You now have permission to sue this person in erkaos, in secular court, and it's under those conditions that you can take a fellow Jew to secular court, but it's then and only then. Yes, Simi.
To what extent there isn't a case that's available, or they don't have subject matter expertise? To what extent you have to find a Beis Din as opposed to a non-Jew?
That's a good question. The poskim do discuss as to how far a person has to go in order to find a Beis Din, but it seems like that's not a halacha l'maisa question today, because there's always the opportunity to constitute a Beis Din. It's just a question of how much are you going to pay. You can either travel to a Beis Din that's in a nearby city, or you can fly in 3 rabbanim and constitute an ad hoc Beis Din in your location. There's always a way to do it bisman hazeh. There are discussions in the poskim, if you live in Yehupitzville, and in those days it was not easy to travel, sometimes that was the function of the Rav Ha'ir, of the Rav of the city, that he would adjudicate those kinds of cases when a Beis Din was not readily available. But that in and of itself does not automatically give you the right to litigate in a secular court. Okay. So under what circumstances can we circumvent this halacha? We've already learned that in a situation where you know for a fact, because you've sent the guy a hazmana and he refuses to appear before a Beis Din, that you need to get permission granted from the Beis Din, and if the Beis Din gives you that permission, you can take him to secular court. Turn to the final page, and I want to show you a footnote from a sefer called Kesef HaKadoshim, from the Machaber. His name was Avram David Borman, the Rav of Batachach, I think it's how you pronounce it, in Ukraine. He was also the author of the Eshel Avram. Yeah, and the sefer Kesef HaKadoshim, which is a commentary to Shulchan Aruch Choshen Mishpat, writes, he says as follows: you first, and source number 6, you send a person a hazmana first, and if he refuses to heed the hazmana, eventually the Beis Din will give you a writ granting you permission to sue him in secular court. So he writes, Gam she'ein leilech be'erkos shel goyim kodem rishus mi Beis Din hatzedek Di'im b'nei Yisrael. He says, it sounds like from what the Shulchan Aruch writes, that you cannot sue someone in secular court until you actually get formal permission granted to you from the Beis Din. Mikol makom mi sheyadua alav sheyodea me'elav chiyuv shelo la'asos avla. He says, mi sheyadua alav sheyodea me'elav chiyuv shelo la'asos avla. He says, if there's someone who is known and that it's sort of self-evident, I guess what it's referring to is someone who's sort of like a political appointee. I think is maybe what he's referring to. Or there is a fairly accurate sort of assessment that the person that is your opponent will certainly never appear before a Beis Din, and he says it's an umdina yedua l'rabim, and it's something that is well known to the public. In other words, this is a guy, maybe he's not Shomer Shabbos, maybe he has no familiarity with Jewish traditions, and maybe if only 3 people in the community are aware that there's no way this guy's going to go, just as if like sometimes you can get 3 people to act as dayanim for an ad hoc Beis Din for certain smaller hearings. Lazus Fosaim ki omed lihisparseim da apetlasa matzel mebechinas iser lashon hara. And he says that there are certain times that appearing before 3 people will be adequate, even if these 3 people are the only ones who know that this person will not go to Beis Din. And his argument is that sometimes when you say something disparaging in front of 3 people, it's not considered lashon hara if it can be interpreted in 2 ways, because we know that it'll eventually get back to the person himself. And perhaps even if they're from out of town, people know that this fellow will not go to Beis Din. As long as you have, basically his argument is, as long as you have an establishment that's fairly certain that this fellow would never go to Beis Din. Yesh lomar sheshayach bazeh me'ein masha amru chazal chaver ein tzarech hasra. Just like the Gemara in Sanhedrin says that there are certain kinds of Jews who know the halacha so well that in order to punish them, the Edom do not need to give hasra, the Edom do not need to forewarn the individual. So too, in this kind of situation, where it's so obvious, it's so self-evident that this guy's never going to go to Beis Din, so then you can bypass the standard procedure of having first to get permission from the Beis Din, and you can just take him straight to court. The gam de lo kaimelan sham kain, kol makom legabe hasra legabe mishpat yesh lomar shemol umdina kenal. And even though we normally don't paskin like that Gemara in Sanhedrin, that even though it's self-evident that this fellow is a chaver, he's a knowledgeable person, and still we require the Edom to give him hasra, yet perhaps for these purposes, where it's just in order to be able to do the inevitable, which is to take him to secular court, this would be okay. So it's on this basis that there are some poskim who want to rule that when you're suing a corporate entity, even though the corporation is owned by Jews, but you know that the corporate entity, based on sort of the way that this corporation does business, they're never going to submit to a Beis Din, then you wouldn't have to actually send them a hazmana first, but you could take them straight to Beis Din. Now, I do want to point out, I remember reading this article over 20 years ago. The Wall Street Journal published an article that a chain of hotels, I don't remember, it was Marriott or Hilton, I don't remember which one it was, had a dispute with one of their vendors who was a frum Jew. And the vendor suggested that they go to Beis Din. And surprisingly, the hotel said, okay, we'll go. And then the Wall Street Journal wrote up a story about their positive experience going to Beis Din to adjudicate their difference. Because when you think about it, really from a secular perspective, what is a Beis Din? It's really an arbitration panel. It's really a group of 3 arbitrators who are basically the 2 litigants submit to their authority and basically say, we will accept whatever ruling you make about us. And it saves a lot of money, especially if there's, court fees and lawyers' fees and things like that. You can bypass all of those costs and expenses and go to Beis Din if you trust the Beis Din and you feel that the Beis Din operates professionally, right? So, yeah, Archie. It's not free, of course not. You have to pay for their time. They're sitting and adjudicating. They're taking hours upon hours of time. But it's certainly much less expensive than hiring lawyers. A lawyer can charge up $500 plus per hour for his services, and that's completely outside of court time. So most of the fees that you're paying for are not for the time that you're appearing in court. And the dayanim are primarily charging you an hourly fee for the time that they appear in court and the time that they deliberate among themselves. So it's a much shorter amount of time of hours that you're paying for, and it's a much lower hourly fee. Yeah, Harold. Absolutely. There's a very serious problem of misayeh. That's one of the tshuvas that we did, where a lawyer wants to know, am I allowed to help a client who was suing another Jew in secular court? And according to most poskim, if you're from a yid, you have a serious problem of misayeh yidei ovrei aveira, at least the nisr de rabbanan, of helping another Jew do an aveira, perhaps even a violation of the doraisa, unless you can justify that the other side simply refused to go to Beis Din. And generally speaking, we don't rely on this heter of the Kesef HaKadoshim unless we're dealing with corporate entities. If we're dealing with an individual, even if there's an umdina that the individual is not going to go to a Beis Din, you still at least have to try. You have to try first and get permission from the Beis Din after they send them a hazmana. Yeah.
that's the prerequisite.
Mhm.
Two parts, right? First, you have to have that, and then continue. The nafkamina would be
Mm.
would this halacha ever take?
Well, there you could also argue that it's Yad Goyim Takifa, because at the end of the day, the government, when it comes to Choshen Mishpat Halacha, the Medina prevails. In other words, if a person says, I want to go to Beis Din, but the other party says, I'm suing you in a court of the Medina prevails. That's basically what he's saying. In other words, Yad Ovdei Kocha Takifa simply means I can't control the situation if a guy sues me in secular court or I sue him and he refuses to show up. I have no other options. And that would probably be true in Israel today as well. Yeah, Batei Din don't hear Dine Nefashos today or Dine Kanasos today. Yeah. Penalties. We don't assess penalties either. Which really leads to an interesting shaila, which is as follows. What happens if the person that I'm suing, I'm really suing them for their insurance? It happens all the time. I'm involved in a fender bender with another from a Yid, driving down York Hill Boulevard or Clark or wherever it is, or Bathurst, and all of a sudden we get into a collision. He says, it's your fault. I say, what are you talking about? It's your fault. It's so obvious it's your fault. And he says, what are you talking about? It's so obvious that it's your fault. You got to love Jews. Everything's obvious to the other, right? So anyway, I'm just making all this up, right? And so what do? So they say, well, let's go to Beis Din. Well, what do you mean, let's go to Beis Din? We have to write this up for the insurance because I'm not going to pay for this. And there's no fault insurance in Ontario. Let's just get the insurance company to cover it. And the other guy says, well, I mean, in a situation where the other guy just drives off, then you have a serious issue. Like, what happens if he just drives off and he doesn't agree? So what are your options? Do you have to first take him to Beis Din, or are you able to just sue him in secular court based on the fact that the money that you hope to extract from him is his insurance policy and not the money from him himself personally? So alzeh anudanim, and this is the subject of a lot of tshuvas in the poskim. Is there an automatic permission granted to a person to go to secular court when the party that's liable to pay will not be the frum Jew, but is representing the frum Jew, such as an insurance company? So I want to show you a tshuva from Rav Zalman Nechemya Goldberg Zatzal, who was also a chaver Beis Din of the Beis Din Hagadol in Yerushalayim, which the topic is Chiyuv Chevrat Bituach Shelo Al Pi Din Torah. What is the obligation of an insurance company when they pay out not using the laws of the Torah? So he says, Nosei Chashuv Ma'od Hu Be'inyan Shel Bituach. He says there's an important issue when we talk about insurance. Bifrat B'Bituach Chalila Shel Ta'onat Derachim, especially when it comes to automobile collision insurance, or any kind of traveler accident insurance, I guess. Shehu lichora habituach kishela'atzmo yesh bo ma'ale gedola ma'od, which obviously there's a great advantage in having insurance when you're traveling. Ulam harbe bayot halachtiot mitorot begin bituach zeh. So first of all, he just wants to remind us all that getting insurance is a good thing. No one's advocating that you don't get insurance. But a number of halachic issues may arise from the whole involvement in an insurance company that does not abide by halacha. Ledugma, here's an example. Imra'at ta'onat derachim v'Yehudi paga be'enu Yehudi. Let's say you're witness to a collision. A Jew rear ends a non-Jew in his car. Clearly, the Jew, is at fault. V'yesh eid echad Yehudi hayodea l'tovat hagoy u'lechovat chavero hayehudi. The Jew who witnessed the accident sees very clearly it was negligence on behalf of the Jew, and he really is the liable party to the non-Jew. V'achein matzanu b'gemara ka'asher goy tovea miyehudi v'yesh eid echad Yehudi hayodea edus l'goy. He says the Gemara talks about such a case where a Gentile sues a Jew, and the only witness to be able to show the court that the Jew is liable is another Jew. Ve'al av shenachon hadavar sheyodea be'emet edut l'goy shehayehudi chayav l'goy im kol zeh asur la'yehudi lahayid beveit din shel goyim. But it's still going to be asur, according to the Gemara, for that Yid to go to secular court and testify on behalf of the Goy. Umadua harei ha-Yehudi chayav. But why is that? Why does the Gemara say, after all, isn't the Jew guilty? Ach mekivan shehagoyim machrim et hadin al pi edut eid echad. The answer is that this is one of the fundamental differences between non-Jewish law and Jewish law. In Jewish law, you need two witnesses in order to convict someone or make them liable for payment. In a non-Jewish court, all they require is one witness. And the secular court will rule, based on one person's testimony, that the Jew is chayav to pay to the goy, and that's not according to halacha. Nimtza sheyehudi hameid ke'ed echad l'tovat hagoy harei shehu gorim lahotzat mamon chavero shelo kedin. So if there was actual an establishment of fact based on two kosher witnesses, then despite the fact that it's a Jew who damaged the goy's property, the Jew would be liable. Because in Hilchos Nezikin, there's no difference between Jews and non-Jews. If I injure a Jew, I have to pay. If I injure a non-Jew, I have to pay the same amount. The issue, however, is the evidentiary standards. What evidence is necessary? How do I gather the evidence that the Jew is chayav? If the Jew denies his liability, how do I assess who's chayav and who's pater? So in a secular court, one witness is sufficient. In a Jewish court, you need two witnesses to say the Jew is chayav. So if I'm a Jew and I'm the sole witness to the Jew's liability, I'm not allowed to testify in secular court because I'm aiding and abetting the secular court to extract money from the Jew. That's not according to halacha. V'rak b'makom sheyesh shnei edim shehayehudi chayav l'goy, az hem yecholim laha'id b'dineim l'tovat hagoy ki kein hadavar gam b'din Torah lahotzi mamon. If, however, there are two Jewish witnesses, and I'm walking with my chavrusa and we see the collision, then it would be fine for the two of us to go to secular court and testify against the Jew that the Jew is chayiv to pay the goy for rear-ending him. Nimsa shebe'edus yachid ein laleches ulahoid letovas hashe'eno Yehudi ulechayev et ha'Yehudi. And therefore it turns out that in this kind of situation, you know, even though you're dealing with insurance money, you would not be allowed to testify in a secular court. Va'af b'makom sheyesh od eid echad pasul, yehei asur le'eid ha'Yehudi ha'yachid aleched ulaha'id. And even if there is a second witness, but he would not be admissible in a Beis Din because he's not a kosher witness, let's say it's a female, which is, again, opens a whole can of worms. So then the Jew would have a problem going to testify in a secular court. So that's one problem. That's one problem that arises whenever there's a secular court hearing. This is really not even so much relevant to insurance, but you'll see how it ties into insurance in just a moment. Od baya nosefet, k'mo chiyuv begin agmas nefesh, she'ein bahem chiyuv mamoni al pi din Torah. Another relevant issue is what about pain and suffering? In a secular court, when an insurance company is called in to pay for a person's damages, the court will assess pain and suffering as part of the restitution that the insurance company has to come up with in order to pay the injured. Okay, but there's no such assessment that would be made if you went to a Beis Din, because those are assessments that the Gemara does talk about but they are no longer assessed bisman hazeh. Batei din today only assess actual finite physical damages. They will assess medical costs. They will assess the disability of the individual, but pain and suffering is not a tangible commodity that the Beis Din today will assess. Ki al pi din Torah mechayivim al hefsid mamon, ze'eno bahagdoras hefsid mamon. Today, the Batei Din only assess based on monetary law, actual monetary loss. That's not considered monetary loss. Now, it's true that there was a time when Batei Din used to assess knasos, penalties, but we don't have any penalties anymore. The Batei Din do not assess penalties anymore. And so therefore, this would be a huge divide. Like if you go to secular court, a secular court might award a very, very high amount in pain and suffering, punitive damages or compensatory damages. But in a Beis Din, they wouldn't utilize that equation. And therefore, taking someone to court, putting aside insurance for a moment, this would be problematic. Ulam b'makom ve'eno tovea hamazik hapogea ela et cherat habitua. But now let's talk about insurance companies. What happens if the party being sued has an insurance policy? So it turns out that really what you're doing is, even though you're naming the defendant as Plony, as the person who rear-ended you, but really the person who's going to be vigorously defending the case is the insurance company of the defendant. And therefore, ki chevrat habituach mitchayevet b'chiyuvim she'enam milechatchila kechova al pi din Torah. He says, because an insurance company is not a liable party to this, but they have accepted upon themselves outside the rubric of halacha to make themselves liable for anything that the courts tell them that they are going to be liable for. So that an insurance company is a guarantor for anything that is assessed in the secular court. And we know that this is halachically valid. For example, what if, I ask you to watch something for me, and you say, I'll happily watch it for you on the condition that I am not liable if anything happens to it. Are you allowed to do that? Even if the halacha would normally state that you are going to be liable if you're negligent? So I say, listen, I don't want to take any responsibility for your object. Sometimes I leave the house and I don't lock the door. Sometimes I leave my briefcase that may have your object in it in my car and it's unlocked. I don't want to take responsibility. If you're willing to leave it with me and whatever happens, happens, and I'm not going to be liable under any circumstances, I'm happy to watch your object just like I would watch my own stuff. And that is valid, halachically valid. You can structure a deal no matter how you like it. Conversely, a person can create a scenario whereby he accepts upon himself a higher level of responsibility of shemira, more than what the Torah would obligate it. So for example, I ask you, do me a favor, let me borrow this item, okay? Now, what is that called? That's called the shoel. Right? If I say, let me borrow it, or let me rent it from you, I want to be socher it. Now, a socher has certain levels of liability. But let's say the object that I'm borrowing from you or I'm renting from you is worth $50,000. But we make a deal between ourselves and we say, promise me that if you lose this item, it has such sentimental value to me that you will pay me not the true value of the object, but you'll pay me $150,000. Are we allowed to make such a deal between ourselves? Absolutely. As long as two parties consent to the conditions of the financial arrangement, that's perfectly fine. So if we decide that I'm going to watch your $50,000 object, but if anything happens to it, I'll pay you $150,000, that's perfectly fine. In the same vein, an insurance company can basically obligate itself to a higher degree than the halacha would demand a person who is a guarantor has to pay. So let's say, according to halacha, if a person gets injured and a person is a guarantor on that person's injury, they would only have to pay X. But a secular court would hold them to be liable for X plus Y. Once the insurance company contracts with the insured, they're basically saying whatever the secular court tells us to pay, we will pay for you. And therefore, it becomes much less problematic to sue someone when they have an insurance policy in secular court, because that was the arrangement that was made with the insurance, that the insurance company made with the insured, that we will cover you. We are a non-Jewish entity, and therefore, the person that you're taking to court and that you're extracting money from much higher than the Beis Din would obligate is completely prepared to do that and arrange to do that in advance. Okay. Nimsa ki chevrat habituach mitchayevet gam kisheina b'chiyuv shomrim ella mitorat hitchayvut. Okay, so they're not obligating themselves for damages. They're basically saying whatever we're told we're liable to pay, we will pay. Barur she'ein isur lahayid eid echad b'hotzoas mamon l'chayvet chevrat habituach. So in that situation, you could testify as even one witness in a court of law, in a secular court, even if you're a Jew who witnessed the Jew rear-ending the non-Jew. Because the insurance company, who's the one who's being sued, agreed that whatever the secular court tells us to pay, and under whatever conditions they tell us that we're liable, we will abide by. Since the secular court says that one witness's testimony is admissible, the insurance company says, fine, we accept that. And the same thing is true if you go to a non-legally constituted Beis Din. And therefore, it's no different even if you went to Beis Din and a person, let's say, said, in order to extract money from me, you need two witnesses. But you know something? This fellow, he's going to testify. I trust him like two witnesses. That's okay also. All right? Now, I'm going to skip the next paragraph just for brevity. And for the doctors in the room, this next part is also very relevant. He says, Mikre domen nish'alti berofei sheta'a o beit hacholim sheta'a. I was also asked this question when a physician committed malpractice or a hospital committed malpractice. Uvishel kach tavu otam b'pitzui kaspi gavoa. And either the physician or the hospital was sued for a very high amount, an amount much higher than they would normally be awarded if they went to Beis Din. Okay, so let's say there's a frum physician, he's a frum surgeon, let's say, and he commits malpractice. He does something that he wasn't supposed to do, and it was gross negligence. Do I, as another fruma yid, have a right to sue that doctor in secular court? And the answer is, I'm suing his malpractice insurer, right? I'm not suing him. Vizot begin shepagu ba'adam shetzarach lahotzi avuro kesef rav. V'hinei al pi din Torah rofe shetar pater mitashlum takonas chachamim v'nei tikkun ha'olam. Now we know that the chachamim made a takana that when a doctor makes a mistake, he's not liable to pay. Chazal say that a rofe that made a mistake, we're not going to hold him liable for damages. And the reason is because if we did, people would stop being doctors. Okay? I don't know. I mean, I don't know that he's making that distinction. Malpractice doesn't mean he was drunk. Malpractice just means that he. But there was some negligence involved in the mistake. You have to be able to, don't you have to be able to prove negligence and the standard of care? Right.
Standard of care. Negative outcome.
It was one of the risks. Yeah.
One of the things that happened, as long as you met the standard of care, someone else practicing in this domain would have done the same thing, then that would be a standard of care. And that's on lawyers.
Yeah. But you have to, so to prove malpractice, you have to show that it wasn't according to the standard of care, that the doctor maybe said that you need a surgery that you don't need, or that the doctor, who, let's say, a doctor wasn't licensed to perform a certain procedure. Like I know of a certain case where a guy is a podiatrist and he called himself an orthopedist and was doing surgeries, and he lost his license in the state where he was practicing. Okay. Or let's say a guy is, there's a lot of situations like that.
Take one and just disagree. So as long as you can garner and supporting that there is a medical approach to that, says I took that opinion.
Right.
So,
But that's within the standard of care, right? Right.
Otherwise, someone saying, why didn't you do X, Y, or Z at such time?
Yeah. So anyway, Chazal made a takana that when a rofe makes a mistake, that he's pater from tashlum, he's pater from paying, ki rabim yimnu milasok birafua, because if we make it such that the stakes are so high against a physician for making mistakes, no one's going to want to go into medicine. And that's true. Even if there was negligence involved, we still have to deliberate that perhaps that takana extends even when a doctor is guilty of negligence. And he says, but no matter how you look at it, even if a person who committed a negligent act of medical practice would be held chayiv in a Beis Din, but it certainly wouldn't rise necessarily to the amounts that the secular courts would grant a patient who was a victim of malpractice. Ol kolzman sheyesh bituach nitan b'shufi litfoa et chevrat habituach ki ein habituach kafuf lidin Torah. But once again, if the doctor has malpractice insurance, which is necessary in order for him to be certified as a practicing physician, there is absolute permission granted to sue the doctor in secular court because you're really suing the insurance company. As we said before, the insurance company can obligate itself to pay more than what the Torah or what the Beis Din would obligate it to pay. And there's no problem therefore at all. And again, like we said before, normally one person would not be kosher to testify in a Beis Din. But that's not true with an insurance company. The insurance company obligated itself to adjudicate according to whatever the courts would tell it to do, and with whatever evidentiary standards the courts imposed. Okay, umemela bayat ribit b'mikra shelo shilem bizman ena bayat klal v'alav l'shalem kefi sheitchayev ubifrat hadavar nikra hatzmada. Okay, and they're going back to a part that we didn't see in the tshuva itself. Let me just see. Another case that he discusses over here is the Gemara talks about a minhag, minhag gadol haya b'Yerushalayim. Madam his min suuda ve'achar kach lo hevio. A person orders a festive meal. He orders a catered meal for his simcha, and the caterer never shows up. The Gemara addresses such a scenario as mishalim demei busha demei bizayon. Then the Gemara, according to Rabbi Shimon ben Gamliel, the caterer has to pay for the embarrassment, for an assessment of humiliation that the Baal Simcha had to undergo for not being able to feed his guests. אבל חכמים חולקים עליו מפני שבושה זה מחמת גרמה כתוצאה עקיפה מהמעשה שלו. But the Chachamim disagree with Reb Shimon ben Gamliel, and they say that the caterer does not have to pay. He may have to pay other kinds of damages, but he doesn't have to pay for the humiliation incurred by the Baal Simcha. Why? Because that was only a grum. That was only a byproduct of them failing to show up to cater the meal. Okay, v'keven shenasa yedei grama min hadini yefshar litvoa, and anything that's done through a causative act and not directly, you can't demand payment for that. V'amnam grama chayev b'dinei shamayim, and even though there's a heavenly cost that a caterer has to pay for being negligent like that, avol sof sof litvoa yefshar, but you can't sue for that. Ulam im lachevrat ha-catering yesh chevrat bituach. But if the caterer has an insurance policy to insure it against, don't most caterers have insurance policies like about food poisoning and things like that? So if the caterer has an insurance policy where, let's say, they failed to cater properly, and therefore the insurance policy can be accessed, then even according to the Chachamim, I can sue not only for real damages, but also for pain and suffering and humiliation that I suffered when the caterer didn't show up to cater my party. And again, it's because the insurance company obligated itself to go above and beyond what the normal halacha would require someone to pay. Chayav, I think the word is shechayav b'dinei shamayim, v'nimtza sheyachol lechayavam al ma shegarmu busha ki ze chelek midin hapshara. Furthermore, I would argue, says Rav Goldberg, that in a situation where I sue a caterer in Beis Din, and the two parties agree that they're going to use pshara to negotiate, the Beis Din can include a payment of pain and suffering or humiliation as part of the pshara as well, because when a person accepts upon himself to negotiate al pi pshara, using negotiation and using compromise, you do include also what you would be chayiv in dinei shamayim, but not ribis. And finally he says, yesh v'kasher chotmim lechevrat habituach mitchayvim beheskem ki yesh lavo lihitayin imam. Beit Mishpat. He says, whenever a person signs up for an insurance policy, the insurer agrees that he will appear to represent the insured in court. Lamasa ein hadavar mechayev b'makom sha'asar al pi hadin. He says that should really not apply where there's an isser al pi dinei Torah for a person to extract money from another. Ulam kasher tovim oto bifnei erkaot zeyoter iser litvoa o litoveya me asher lanitva. Let me just see what he's talking about. Okay. Okay, I think what he's saying is that when you sign an insurance policy, you also agree that if there is a lawsuit against you, you will adjudicate it in a court of law and not in a Beis Din. And really, that should not be binding upon from a yid if it's usher for him to do so. Ulam kasher kvar tovim oto bifnei arkod zeyoter isur litvoa o litoveya me'asher lanitva. When someone does sue you in secular court, it's more problematic for the plaintiff than for the defendant. And similarly, there's going to be problems for the lawyer as well. He says, but when it comes to an insurance company, you are allowed to sign even lechatchila to allow the insurance company to represent you in secular court. It's no different from, let's say, when a person is summoned to court and he has no choice that he has to go. Many times So he basically says, what I wanted to just clarify is that we're not suggesting that we're uprooting the laws of Beis Din in this essay, but there are certain conditions under which that you are allowed to go to secular court. He says, halavai, though, it would be much better if we could avoid this whole issue of insurance and try to adjudicate things in a Beis Din, and so that we don't come to a srach chilul Hashem, like something that appears to be a chilul Hashem, even when it's not. And may Hashem give us the strength that we do not need, or the bracha that we will not need to rely on insurance companies. This didn't give us enough time to discuss the tshuva from Rav Sternbach, who actually states that even when you're suing someone who has an insurance company behind them, you should send the wording of the summons should be that I'm taking you to secular court only if you refuse to go to Beis Din. And that should be the wording of the summons. But bottom line is that many poskim are lenient that when you know that an insurance company is involved in taking care of this person's liability, then you're allowed to bypass the Beis Din completely and sue them in secular court. What about the fact that their premiums may go up as a result? So Rav Sternbach does deal with that a little bit, and he suggests that as part of the settlement, you should give back a little bit of the settlement to the fellow that's insured, because that'll compensate him for, or help at least to offset a little bit of the fact that his premiums are going to go up as a result. Okay, we'll hold it here for today. This is really only part one. And the reason why it's only part one is because this is not the only instance in which you're allowed to go to secular court. There are other situations where a Beis Din simply doesn't have either the authority or the credentials or the expertise to preside over certain specialized cases. And perhaps in a future discussion, we'll go over some of that as well. Okay, any questions, final questions? Yeah. Shar is compromise. That's simple. That's literally what the word means.
Saying, no, you're right, you're wrong. And okay, we'll split it, that's all. You're 100% wrong.
Generally speaking, when you submit to the authority of a Beis Din, you sign off to binding arbitration, and in the binding arbitration clause, you allow the Beis Din to use their discretion to either rule based on din or based on pshara. And so sometimes the Beis Din in their discretion will say it's so clearly obvious that one side is right and the other side is wrong. This never should have come before us. So we're going to throw the book at the guilty party and make them pay the full amount. There are other times when the Beis Din will recognize that one party is more in the right than the other, but because they wish to have the other party save some face, save some dignity, they will not give the full award to the other party, but will rather, let's say, give 60 or 70% to the rightful party and allow the other party to have leave with some level of dignity. It is usually up to the discretion of the Beis Din. However, there are instances where the Beis Din will say, because the plaintiff asks for it, we did recently have a case like this, where we said explicitly, we are not interested in pshara. We are confident that the person that we are taking to court is in breach of contract. It is black and white that they owe us this money. We are requesting that the Beis Din not adjudicate based on pshara, but based on din. We know what we're entitled to. And so a plaintiff does have that right to say that, and he has a right to say, I'm not signing on the binding arbitration unless I am granted that opportunity. But he could also lose. Yeah, he could also lose. It's a gamble. You have to be really confident in your case in order to be able to make that request. Yes.
you saying that you as an aid echad not tell the police anything or go to court or anything like that? Does that make any sense?
That's a really good question, Gerard.
Yeah.
We didn't really talk about making a police report. If you are witness to a Jew in a car accident with a non-Jew, and you know that the Jew is guilty, because let's say it's clearly obvious, all we saw is that there's a problem testifying on behalf of the Jew in court, but not necessarily to make a police report, because a police report is a piece of evidence that will be presented in the secular court, but it's not actual edus that you're giving. It's akin to edus, but it's something that the Beis that the secular court will use. Now, I believe that you could probably make the same argument that Rav Goldberg made in this essay, which is that since in most situations the victim has an insurance policy, then there's nothing wrong with even testifying in court. And therefore, kal v'chomer, there's not going to be a problem in making a police report, which you should do. Therefore, you should do it, because that's what the law requires any witness to do. I don't know. Isn't there like a Good Samaritan law or something like that? That if you witness a crime, you have to report it? Is there something like that? I don't know. We don't have enough lawyers in the audience tonight. Just a bunch of doctors and dentists and other people. What? Engineers, yeah. That's right. I'll have to ask Marvin about that tomorrow.
Goldberg's premise, and said that in the case of the Eid Echad, that would carry weight in the secular court, it could be problematic.
Right.
But the whole issue of our Kol Shalahem is the chiddush that we started with the evening was, even if they paskin like Israel, it's prohibited to go, which means, of course, if they don't paskin like Dinei Yisrael, it's a problem. So the whole issue of it doesn't. I'm not sure I understand where he's saying that he's going to differentiate between Eid Echad and not Eid Echad. The whole situation is such that.
Well, I'm summoned as an aide. Let's say I'm not a party to this case, but I know evidence. Once it's in secular court, am I a misayeya lidei over avera by testifying in the court on behalf of one party over the other? That's in itself a question. I guess, right. I'm not one of the litigants, so I'm not in violation of ve'ela mishpatim asher tasim lifneihem, like the litigants are. But perhaps you want to argue that I'm a misayeh yedei over avera, even if there's two witnesses, right? Even if there's two Jews who are kosher witnesses and we're testifying in court. Yeah. Right. So maybe the argument is that because the courts are going to summon me, maybe I have that cover that the courts have summoned me, and therefore I have an obligation to go. But if I'm in Eid Echad, then I have to actually try harder not to go. I don't know. It's a good point you're making. Yeah, it could be that because of Dina de Malchus Dina, you may have no choice but to go. The question is, should you volunteer to be a witness? If you're an Eid Echad, I think really maybe it's before the fact of going to court. Maybe the issue is like this. I'm one witness, so maybe it's best for me. The argument would be to not testify as if the victim is not insured. What Rav Goldberg is saying is that you don't have to cheshbon like that. You don't have to have any of those cheshbonos in your mind when you're witness to an automobile accident, because there's never going to be a problem of making a Jew liable for something that is not liable for because he has an insurance policy. I think that's really his main argument. Okay.